Hey, if this one looks like one of those Twilight Zone things, I will explain. We did a live recording earlier today, and unfortunately, the audio didn't show up. So we're having to redo our live recording. So apologize for that. And once again, we welcome you to our live stream. Today, I'm going to discuss three things that people have contacted me about, especially recently. If you have any questions, you can feel free to post that in the status bar question, and we can answer those questions as they come in. If we don't get to the questions today, we will keep a note of them so that during our next live screen we can and get to them. So the first question I'm going to deal with today is somebody who called in asking me the meaning of advanced parole. Could they get it? And I'll explain about advanced parole. Advanced parole is what the USCIS gives you when you have an adjustment application pending before it. Normally, you are expected to be in the US and wait for your green card application, that is your adjustment application, to be processed. If you leave the US while your adjustment application is pending, that application is going to be denied because the USCIS presumes that you've abandoned it and you've decided to go out and you get an immigrant visa while you're out to enable your return to the US. So if you have obtained advanced parole before you travel, then the USCIS will understand that you're not abandoning your green card application, you're not abandoning your adjustment application. When you've applied for advanced parole, you need to wait and have the permission in your hands before you travel. These days, they give a joint adjustment advanced parole permission if you've asked for it, as well as your employment authorization. You'll find that your EAD card will also be your advanced parole permission. What advanced parole does not guarantee is that you'll be allowed back into the US after your travel. And this will affect people who have accrued periods of stay without, who have stayed beyond their permission. So let's say, for instance, you were allowed into the US for 90 days, and in the process, you started an adjustment application, but you stayed behind. You stayed longer than your 90 days, and then you apply to adjust status. If you need to travel, advanced parole will mean that you're not abandoning your green card application, but it's really not a guarantee that you'll be allowed back into the US, because for those who have accrued days over their allowed stay in the US, you could have triggered the 3-year ban or 10-year ban from returning to the US. So even if you have advanced parole, you may find out that you may not be allowed back in. The ideal candidate for advanced parole is somebody who is adjusting status, who has applied to adjust status while still in their period of allowed stay in the US. Those people, they can always travel and return without having been deemed to have abandoned their adjustment applications. If you come to our office, we tend to be risk averse, and you'll probably be advised to wait until you have your green card in hand before you travel. If you're one of those people who has had a time, who has stayed over their allowed stay in the US. Then the next question is, what is the difference between change of status and adjustment of status? You change status from one non-immigrant status to another non-immigrant status. You adjust status into becoming a permanent resident. So let's talk about change of status first. For the person who wanted to know, and I think for other people too, I guess, you change status from a non-immigrant status. Say you came in as a tourist and you want to become a student. You change your status from being a tourist, a B visa, to being a student. It could be an F student or it could be an M student. You could also change your status from being a tourist to being a non-immigrant worker. For instance, you can change from being a tourist to being an L immigrant. You can change from being an L immigrant to being a student. One thing to know about changing status is that you need to be in one status and then change to another status. If you've had any lapses, any gaps in status, you're probably not going to be able to change to another status. So that's that about change of status. Regarding adjustment of status, it's like it is changing from not having a status, or maybe changing from a non-immigrant status to the status of being a permanent resident. So you could go maybe while you still have your green card. I'm sorry, excuse me. While you still have your student visa, let's say you get married, you adjust into being a US a permanent resident. If you get married to a US citizen, or maybe an employer petitions for you, upon approval, you'll adjust from the non-immigrant status of maybe a tourist or a student or a non-immigrant worker into being a permanent resident. Adjustment always goes with permanent residence or green card. Sometimes too, there's people who don't have a status any longer, and they can still adjust status into being permanent residents. That's to say, green card holder. And that, of course, depends on your particular case. So if you call our office, we can always look into your case and tell you what it is, whether you're going to be able to adjust or to change status. Then we will also ask the question, what's the difference between a green card and a permanent residence? The short answer is none. There's no difference between a green card and permanent residence, except in maybe the semantics of the English or just English description. So if you're a permanent resident, that's the status. A permanent resident is somebody who is allowed to live and work in the US without a termination point. You can travel, come back. You can live as a permanent resident for the longest time. You're just shy of being a US citizen. The green card is an actual card which you're given to show that you're a permanent resident. So more colloquially, more less formally, one can say a green card holder. If you're a green card holder, if you have a green card, then your status is that of a permanent resident. Your green card is just evidence, mere evidence of your status as a permanent resident. So that is it. That it is about a green card holder and a permanent resident. We also asked the question, I have a green card and I was jailed for an offense, and what's going to happen to my green card? Well, in certain instances, if being jailed, a conviction, being jailed for an offense could cause you to lose your green card. However, one thing to understand is this: that green card is not going to be straight away taken off away from you. You're going to be passed through the immigration court process to discover if there's any reason why you should still be allowed to hold on to your green card, although you've been convicted and although you've served your jail term. So let's go deeper into this then. So it's a good thing to know that immigration, the USCIS, looks at convictions differently from how everybody else and how other aspects of the law look at a conviction. They also classify offenses different from other people. So there's aggravated felonies, a class of offenses they call aggravated felonies, and they also have a classification for crimes involving moral turpitude. An aggravated felony is an offense that makes you serve a jail term of a year or more. So if your jail sentence is 365 days, it's an aggravated felony. And once you have that conviction, you're going to be in jeopardy of losing your green card. Also, certain crimes involving moral turpitude. Sometimes, what's the crime involving moral turpitude? Well, there's no definition of it except that it's a bad crime. You know it's bad. You went ahead and did it. A lot of the times we find that there are crimes that involve fraud. So things like defrauding somebody of money, wire fraud, postal fraud, or even the simplest thing like you jumped the turnstile. You didn't want to pay your fee to ride the subway. You didn't pay $1.50 to ride the subway. That's a crime involving moral turpitude. It will be classed that same as somebody who defrauded another person of money. Now, an interesting place is where the fraud offense is for more than $10,000, it's going to be an aggravated felony. That the amount of money also matters. So if you have an aggravated felony or a crime involving moral turpitude, you are in jeopardy of losing your green card. However, there's ways when you go to walk around to get around that. You may be able to file a waiver if you have a qualifying relative or other extenuating circumstances, which if you come to our office, that can explain well in your case. Another thing to say about the crimes in immigration law is this. Immigrants really and crimes, they don't mix well. So if you're an immigrant, it's a good thing to keep away from crimes because the simplest thing could jeopardize that green card for you. Like I said earlier on, what immigration will call a conviction is also different from what other areas of the law will define as a conviction. So if you admit to the elements of a crime, that could be called a conviction in terms of for immigration purposes. If you go and accept a no contest plea, which you call it a nolo, a lot of people call it a nolo contendere. If you plead nolo, ordinarily in criminal law, hey, that's not quite a guilty plea. But immigration will deal with a nolo as a guilty plea. So if you have any of this, it's always a good time. It's always a good thing to consult an immigration lawyer whenever you have that intersection between criminal law and your immigrant status. It's a good thing to consult a lawyer so that they will advise you. In our office, we can advise you on how to work on it and maybe get relief. Sometimes for some people, there's really nothing else can be done and they end up being removed from the US. And even for those who manage not to be removed, the law says that an aggravated felon cannot become a US citizen. So you may be stuck with being a a permanent resident for however long you decide to stay in the US, of course, unless the law changes. So that's the question those are the questions. Oh, I'm getting another question. That question is, let me tell you what that question is. Oh, this person is asking me, what's the difference between a visa and an I-94? I'll explain to you. So, in essence, when everything is said and done, a visa is something you get from the embassy. It will only from the US consulate in your country, and it will allow you board an aircraft or a ship and arrive at the border, or you drive up to the US border if you have a visa, and then you ask to be allowed to to be allowed into the US. You're at that point where you come in, you meet an immigration officer. Could be at the airport, could be at the land border, could be at the seaport, and you come in and you want to come into the US. The CBP officer, the Customs and Border Patrol, is in charge of our borders, and they'll be the one to determine whether you can come in. And if you come in, how long you're allowed to stay for that visit. So for instance, let's say you went to your country and you are given a visa for 5 years. That's regular now. 5 years, and you're allowed. It's stamped a multiple entry visa, valid for 5 years. What that means is that for the next 5 years, you can go into the US any number of times. So when the aircraft, let's say the airline company sees your visa, they know, oh yes, he's allowed to go. So they let you board and they transport you to the US like you want. You meet the immigration officer. The immigration officer will allow you in and tell you you're allowed to stay for 6 months. It's always a maximum of 6 months. So that 6 months is the time you're allowed for that visit. So you're allowed to remain for that visit, you're allowed to remain in the US for 6 months. At the end of the 6 months, on the last day of that 6th month, you must depart the United States. So that is the difference between a visa and a stay. A stay, they would normally put an I-94 card, give you an I-94 card, or put a stamp in your passport telling you how long you're allowed to stay for that visit. But these days, it's no longer like that. It's all done electronically. So you have to go to their CBP website to retrieve your stay. So it's important that once you come in, since you no longer have physical evidence of the time you're allowed in, you need to go in to their CBP website and look at it and find out how long you're allowed to stay for that visit. Because if you overstay even by 1 day, the punitive aspect of the law comes in. You'll be barred from returning to the US for another 3 years or 10 years, depending on how long you've overstayed by. And that actually automatically cancels your visa so that you have to get a new visa. So that's the difference between a visa and the I-94, which is the stay, the period of time you're allowed to stay in the US for each visit. And that's it for today. I hope you've enjoyed this stream, and be sure to let other people know. Don't forget to share it. And we really enjoyed bringing this to you today. Hope to see you sometime soon. Bye.